Hi, Kate. Good to see you again.
Hi, it's nice to see you. Thanks for having me.
I'm here in sunny San Francisco. I noticed there was a few boats floating by there behind you.
Yeah, I'm in Georgetown in DC, so I've got the Potomac in the back.
So you were just at the FTC, what, 7, 8 months ago. Now you're at Kelly Dry. So I know you can give us some of that inside baseball on how regulators think, at least if it hasn't changed in 8 months. But so when we were in Denver, we talked about risk assessments. We talked about sensitive and personal data, and you led a great session on data deletions. So we'll talk about some of the issues that came up. With risk assessments, notably California, there's no real regulations or detail on how you do one. And it started to ask this question in the crowd of, well, should you even do one if there isn't specific regulations? And you had a really great response to that. So what are your thoughts, if you don't mind sharing them?
I think risk assessments, it's been a best practice going back over 20 years, and it's just a great way for businesses, for themselves to sort of understand what data they have, how they use it, where it's shared, and sort of whatever plans they have for deletion or any other sort of retention. And I just think sort of puts you in good stead with your business, and then with all regulators, if you sort of have a plan and know how you're using things. So even if it's not an absolute requirement, to the extent you're able to sort of start to do these assessments, I think it's a best practice.
One of the big questions that comes up is anonymization versus deletion. When is anonymization enough? When do you have to delete? How do regulators think about that?
So So as you said, I was a regulator at the FTC for about 14 years until January of this year. And I think regulators have become a little more skeptical about, anonymization. But of course it is, if you can show that you're using an approved method for de-identification and anonymization, that's the best practice. But there is sort of always that suspicion that, things aren't really anonymous. They can be, you can put things back together and re-identify a person, and that's a concern. To the extent a business has a way to show that here's our anonymization process, and you sort of document, and also we commit that we're not going to ever try to re-identify the data, and we prohibit anyone we share this anonymized data with from doing that. I think that puts you in a great position, and sort of a great defense if any regulator suggests that there's a problem with your practices.
And then, of course, if you've highlighted that practice that you'll never re-identify or not use this anonymized data, just to make sure you're absolutely not doing that.
Yeah,
So,
always have a check-in to make sure you're following your own procedures.
yeah. And of course, at the FTC, a lot of discussion around AI. And so in that context with deletion, how far down that path do you go? Like, so for example, somebody says, submits a data subject request, delete my data from the AI model. Step one. Should you do that? I mean, is that covered?
Yeah, it is covered. I mean, there are obviously the different state laws have different exceptions to when you don't have to delete data. So if you follow one of the exceptions, like you're using it, for fraud purposes or something like that, or you can't delete it because it's under, a litigation hold, and like you have a legal obligation to hold it, then you don't have to delete the data. But just generally speaking, you have an obligation to delete the data wherever it is.
As we go down that path a little more with AI, do you have to remove data from the results of the model? Or, what we're really getting at is, once somebody deletes their data, once you delete someone's data from an AI model, do you need to retrain the model so now the outputs don't depend on that person's data being in there?
I think that's a great question that everyone is sort of grappling with now. Like, how can you do that? Are there ways to replace data with synthetic data so that, you don't have to retrain the model? Like, a lot of questions. From a regulator's point of view, I think the first thing that they're going to focus on are those models that are being used to make a decision about people, about their eligibility. So if there's something that's going towards employment, housing, or credit, like those are going to be the areas where you're going to be really careful. And I would say that those are the places where you're most apt to find regulators saying, you have to be able to delete the data. And if you can't delete it, then, you have an issue. But I think that's the first area of focus. Like, further down the lines, for models that are maybe used for other purposes that maybe have like less potential sort of harms to consumers, I think sort of an open question about what would be, appropriate ways to sort of deal with those models. It's an exciting world. It's a big topic, and I don't think anyone has all the answers yet.
Yeah, so what do you do in that? What do you do in that context? I mean, somebody interesting discussion when we were together in Denver was, I think somebody said, "Well, hey, the FTC stance is something like, if you can't do these things like a deletion, then don't use AI." But we don't know how far the deletion goes, and also there's some understanding of the tech that needs to happen, right? Like not all parts of the model are explainable. Some things aren't technically possible. Like, how do you resolve or get to an answer on some of those things when there's so much ambiguity?
So I think, again, it's sort of like a risk assessment process that you need to do. So again, to the extent that you're using a model for one of those sort of big areas of focus, like something that is making an eligibility determination, I think the regulator's approach is going to be, well, if you can't delete the data, if you can't explain it, then you can't use it. That's going to be the position, I think. It's more complicated, I think, when you start to talk about like marketing and sort of other more less. I'm not sure regulators consider marketing to be benign these days, but many people do. So I think you have to sort of think about, when you're thinking about your models, thinking about the use cases and sort of starting for what is the riskiest use case in terms of potential harm to consumers.
Well, you know what I've been trying to ask you is, what are some of the questions you wish came up in the workshop that you wish people asked you about as an ex-regulator that they didn't, perhaps?
I guess I always want people to ask, like, well, as a regulator, like, how should I respond to these like inquiries? Like, what should I do if I get a request from a regulator? And I always want to tell people that it's important to, really communicate with a regulator. And I think it's important to tell your story, have documented your business processes and how you use the data, but it's like really explain what you do, how you do it, why you do it. Because I think that sort of storytelling makes it seem like it's sort of fanciful, but sort of that ability to really describe things to regulators goes far, because they're looking at a lot of different businesses, they're looking at like a lot of different technologies. They can't be an expert on everything. I mean, they have a lot of expertise and they gather it quickly, but it's really helpful for them to just sort of understand what you're doing, and sort of, I think you're in the best position to tell them what you're doing, to explain how things work. And I think that's really valuable. And more companies, I think, should take that approach in the first instance.
Tell your story, be proactive about it, have it documented. Yeah, I love that. Hey, actually, we haven't prepped for this, but I'll so this is a little surprise maybe. But so I was talking to a leader at one of the industry bodies yesterday, and we started to talk about, are marketers showing up to the privacy conversation? And they suggested that the regulators are operating at too high of a level when they talk about consumer protection for privacy. So he described it as being at the 100,000-foot level. And what he meant by that is the FTC is out there talking about consumer harms and privacy, but it's almost like marketers philosophically agree with that, but it almost needs to be more detailed for them to take action. And some of the examples were, the FTC and others should come out and say, for example, identity resolution, here's how I think you should do it. For example, personalization, here's how I think you should do it. And so I wanted to ask you, Kate, like, is that the right level for regulators to be at, like that level of detail, or are they, yeah.
It's a difficult level for regulators to be at, because they don't want to be so prescriptive, right? Like they worry about putting themselves in a box, but you do want to give people guidance. I mean, I think a lot of regulators, for a while, they were trying to do sort of best practices and give sort of general principles, but they've been doing less and less of that. I mean, I don't really know why, but I think it would be great if we could get back to that, and it's also see more workshops and reports that are sort of built on like getting a lot of information from all the different stakeholders. I think the FTC, for example, used to do that quite a lot, and sort of help that build like reports and best practices that can really give a little more guidance to industry. So I think that would be a great return, sort of the kind of guidance. I don't know if that's on the horizon in the next few months. It seems like regulators are more interested in just issuing rules right now, but there's hope.
Yeah, like the FTC did such a great job I thought, on the hidden costs of pixel tracking, or the hidden dangers of pixel tracking. And that seemed like to be super detailed in the weeds. And I wonder if there's even a tick above that for privacy, as you think about like how the ad tech ecosystem works. And you know, I know they're at the surveillance capitalism kind of level, but there's a level below that where we really unpack, here are the pieces of this puzzle, and let's talk about those. How do regulators manage their front office, basically? So, you know, their PR team that says, well, here's what we're going out with, versus, you know, the lawyers that are there, the enforcers that are there that have specific positions.
Well, I think it starts at the top. It's, you know, the priority setting of the head of the agency and the leadership. And priorities, you know, shift a little bit on what the particular focus might be, like which communities we might be most interested in focusing on. But so it starts with with the priorities. But after that, I think there's a lot of in my experience at the FTC anyway, there is quite a lot of coordination, you know, making sure that, you know, different pieces of the agency, sometimes, you know, different sides of the house, competition, consumer protection, economists came together and sort of talked through issues. And, you know, a lot of times those sort of workshops I was talking about, those opportunities to reach out to stakeholders, those would be put on by, you know, groups of individuals across the agency. And so you'd have like the expertise from different areas of the FTC sort of come together and sort of make sure that all the relevant stakeholders were part of the conversation and that all the right questions got asked.
Gotcha. Thanks, Kate. I appreciate your time. And it feels unprecedented in privacy that there's so much ambiguity. And I love that the regulators are out there talking, but it's also like hearing from folks like you who are just there and can explain some of this thinking is super helpful. I appreciate it.
Oh, my pleasure. It was nice talking with you.
Yeah. Okay. Thanks. Enjoy that view.